Greetings at large. Welcoming you again to the weekly current affairs series presented by IQCivils. For this particular session, we are to deal with four major topics. The four articles which follow are the first one is, as you can see on the screen, Supreme Court refuses to stay High Court ruling, quashing 65% quota in Bihar. The second particular one is can states tax mining activities? The third is the axis of resistance. The fourth one being very important, which is the sub-classification or subcategorization of SCs and STs. Moving about to the first article for the session, I have already highlighted the important parts which you can see herein. It so reads the Supreme Court on Monday refused to order interim stay of a Patna High Court decision quashing reservation up to 65% for the backward classes, the extremely backward classes, and the scheduled caste and scheduled tribes in public employment and institutions. Apparently, the High Court, Patna High Court, had concluded that stretching quota from 50% to 65% in government jobs and educational institutions leaving only 35% for merit was a violative of right to equal opportunity for citizens. Apparently, it so suggests that the two legislations which were introduced by the Bihar government were one was the Bihar reservation of vacancies in posts and services for scheduled tribes and other backward classes amendment act of 2023, and the second one was Bihar in education institutions reservation amendment act of 2023. Accordingly, the Supreme Court and the High Court of Patna it suggested that this particular amendment is ultra biased against articles 14, article 15, and article 16. Article 14 tells us about equality before the court of law and equal protection of law, right? Article 15 talks about prohibition of discrimination, yes, on the basis of caste, sex, place of birth, creed, and everything. And Article 16 tells us about the equal opportunity in employment, right? So apparently, the 50% limit which the High Court and the Supreme Court has repeatedly mentioned in this judgment has come from the very famous Indra Sawhney judgment, which we very well know about. So Indra Sawhney judgment, the judgment came in the year 1994. Yes. So the background of this particular judgment stays back at the Mandal Commission report, which suggested that some 27% additional reservation needs to be given to OBCs to the existing 22.5%, which was already there for the other castes, which were SCs and STs, right? So this was the major recommendation by the Mandal Commission report, and apparently what happened in the year 1991 was the PV Narasimha Rao government also came down to the fact of acknowledging the commission's report of giving 27% quota to OBCs, and at the same time, what did the Narasimha Rao government do? Along with the 27% quota to OBCs, the Narasimha Rao government also introduced an economic criteria, which was for the economically weaker section among the people who did not have any kind of benefits from reservation, right? So therefore, meaning the upper caste or the general caste people, right? Now, this particular thing was challenged in the court, and apparently, we come down to the fact of Indra Sawhney judgment. Indra Sawhney judgment therefore comes to down to fact and gives six important priorities in the judgment. The first one is that lead to the 27% quota to the OBCs, right? Second, the judgment said there can be no 10% reservation to economically weaker section because the conception of reservation in India is a little differently placed. It is not on the it is on the economic perspective, but the historically oppressed classes, right? For that matter, caste. Now, the third aspect was that among the OBCs, the government are to take care of the creamy layer, right? The government are to take care of the creamy layer. Apparently, the well-off section of the OBCs are not to be considered in the list of the OBCs, right? In this particular thing, the government also created a committee which was called the Ramnandan Committee for classifying who will be the people coming down into OBCs and who will be coming and who will be the people who will not come into the non-criminal layers of the OBCs, right? The fourth aspect was that apparently there were certain other sections called as carry forward, and the fifth aspect was promotion, reservation and promotion right. So both of these particulars, the government said it cannot be done. Promotion was not allowed. However, carry forward is allowed, but this was also allowed to be subject of 50%. Now, the most important fact is that the Indra Sawhney judgment limited the reservation provision only until 50% of the total number of seats. Along with all these six provisions or important areas of the judgment, what the Indra Sawhney judgment also took care of was to establish a statutory or permanent statutory body for the betterment of the OBCs, which later now has become NCBC or constitutional body under the Article 330, 338 B, right? So this is majorly about the Indra Sawhney judgment, and Indra Sawhney judgment was majorly important. Why? Because recently such things did happen in Bihar, and the Supreme Court had to come in to talk about the 65% and 50% reservation. All right. So moving on to the next topic of this particular session, the topic so says that can states tax mining activities. Now, before going on to the details of this particular article, recently, I would also like to include that recently the government, for some 12 critical minerals, for some 12 critical minerals, they approved the royalty rates. So therefore, while you approve the royalty rates, it also means that the government is ready to auction the blocks for the first time in India, right? Apparently, in the previous Lok Sabha, what happened is the government amended the Mines and Minerals Regulation Act uh, 2023. Apparently, in this particular amendment act, some 24 minerals were taken care of as excellent strategic minerals in the schedule of the original act, which was added, right? Apparently, this number of critical minerals become important from the perspective of filling, where they are found, where they are not found, what are the critical materials, minerals for that matter. We are entirely dependent on imports. Even if we have got sufficient amount of mineral deposits in India, why is it particularly that we are only going after import? For that matter, there are other countries like South Africa and Australia, the mining sector of which contributes some 7 to 7.5% to their GDP, right? However, the Indian mining sector, it contributes only 1.5% to India's GDP. So there's a huge lag. Sorry, 1.75% to India's GDP. So therefore, it is a huge gap. And apparently, the geological potential that we have, of whatever potential we have, only 5% of it is being mined in India. And of, of being explored, it is only 10%. So apparently the mining sector has to improve, mining sector has to go down. And along with 24 critical minerals which were taken care of by this particular act, the Ministry of Mines also constituted a committee which was headed by Dr. Veena Kumari Dharmal, who was back at that time the secretary of that particular ministry. Uh, the committee so suggested some 30 minerals which were found to be most critical for India, out of which two minerals are critical as fertilizer minerals, right? So among them, antimony, beryllium, bismuth, cobalt, copper, and many other were there. All of these particular critical minerals become important from the perspective of prelims. Where do we find them? Where do we not find them? Right? How much do we import? How much do we export? All of the export cost reason no, but yes, imports we are definitely getting into fact, and of course we need to know what are critical minerals. So this is something which you need to take care of, right? Now going back to the particulars of the article, I have already highlighted the important sections herein. Reading out to you, it so reads that the Supreme Court affirmed that states had the legislative authority to impose taxes on minerals in addition to the royalty levied by the center, right? So this so suggests that the states can, of course, go about with a different kind of tax along with something which we call royalty. We'll definitely know what is a royalty and what is a tax, apparently the most important part of it so says the verdict clarified that the power of state legislatures to tax mineral activities within their respective territories is not constrained by Parliament's Mines and Minerals Development and Regulation Act of 1957. There was a dissenting judgment here from Justice B. Nagaratna. She so said that to caution rather that allowing states to impose additional levies could hinder the development of the nation's mineral resources and disproportionately advantage mineral-rich states. Right? Now let us go about the details of the case. Whatever happened. So reads that the Section 9 of the 1957 Act requires those who obtain leases to conduct mining activities to pay royalty in respect of any mineral removed to the individual or corporation who lease the land to them. Right now, in this particular arrangement, what became the key question was for consideration was whether the royalties paid by mine leaseholders to state government under the 1957 Act should be classified as tax. So this was one of the major implications of this particular thing. And also, additionally, the court needed to determine whether the center could impose such charges or if the states possess the sole authority to levy them, levy them within their jurisdictions, right? Apparently, what happened is the dispute, the genesis of the dispute, it lied between a case of India Cement Limited and against the government of Tamil Nadu. There was a similar kind of a story which happened with West Bengal and Kesoram Industries Limited. And recently there was a Bihar law which also imposed a cess on land revenue from mining bearing land. And apparently from this particular thing, the case was referred to a nine-judge bench definitely to settle the legal position. Now, apparently, what is the difference between royalty and tax? The article so says that the royalty is a contractual consideration paid by the mining leasee to the lessor, who also may be a private party for the right to extract the minerals, right? And apparently, what is a tax? A tax was characterized as an imposition by a sovereign authority. Okay. Now, the important part herein is there are two entries in the one in the state list and the other in the union list. Now, the dispute in the case is kind of tried to be solved by considering the uh, uh, considering the seventh schedule of the Indian Constitution. Now, what it so says that entry 50 of the state list under the seventh schedule of the Constitution gives the states the exclusive authority to make laws regarding taxes on mineral rights. Right. So the entry 50 of the state list so tells us that it is the right of the states to actually go and tax the mineral rights whoever has been given the authority, right? And the other entry which is there in the union list, for the matter of fact, it gives the center the power to regulate mine and or the mineral development, especially when the parliament decides it is in the public interest. Now there is a short twist to it. In the entry 50 of the state list, what is different is that the power of the state is, however, limited by any laws the parliament pass to any laws that the parliament may pass concerning the mineral development, right? I think this was something which was talked about and trying to give the center the right to levy the taxes. However, the majority in particular judgment is for reason that royalties could not be classified as a tax and that they do not fall within the category of taxes on mineral rights, which was defined under the entry 50 of the state law. So, therefore, royalties are something different, and taxes, according to the entry 50, was something different. So, they both are not the same, right? So, apparently, now the center is empowered to regulate mining development under entry 54 of the Union List. Yes, that we have already studied here. And the court clarified that this authority does not include the power to impose taxes, which is exclusively under the directive or for that matter, the jurisdiction of the state legislatures. Therefore, to express that this power is subject to any limitation that may be imposed by the parliament, even include a prohibition against imposing taxes. right? So this can also be the thing. So both of these entries, entry 50 and entry 54, therefore becomes important in this particular consideration, right? uh, going to the next important part of this, the majority of the judgment also held that states have the power to tax the land where mines and quarries are located by the virtue of Article 246, read in entry 49, which is taxes on lands and buildings of the state list, right? Apparently, it so says that the state government can definitely levy tax on the land because it is also in the purview of the state list, right? So this is the major idea. Now we have clarified that what is the first reasoning of the article was that the Supreme Court affirmed that the states have legislative authority to impose taxes on minerals in addition to the royalty levied by the center. So this is well established by the fact hearing, right? However, the last part of the article it talks about the dissenting judgment of Justice Nagaratna and why did she have a dissenting judgment? It was apparently very clear at the very first part. So there she said that to impose additional levies could hinder the development of the nation's mineral resources and can disappropriately or proportionately advantage some mineral-rich states. Right? So this is majorly about the critical mining industry and how is it going to impact the economy of this particular country. Right? Moving on to the third topic of this particular session, it is majorly about for that matter, the details of this particular article can be used as further materials when you come across any IR question relating to the Middle East crisis. Right? Apparently, the Hamas leader Ismail Haniyeh was recently assassinated in an airstrike in Tehran. In this particular thing, the Iranian-backed, for that matter, the non-state actors, the non-state actors to bring about its upper hand in the area has been talked about in this particular article. Who are the non-state actors and who have been Iran backing by now or so far to kind of try and influence the politics of the region, right? Now, the Iranian-backed groups, they are collectively known as the Axis of Resistance, and in that particular Axis of Resistance, we can find the names of Hezbollah, Hamas, the Palestinian Islamic Jihad (PIJ), and the Houthis. The Houthis were very much recently in news because of their activities in the Red Sea. Yes. So this particularly makes the topic very interesting and also important from the perspective of Phillips, right? It so says, or for that matter, the article so reads the roots of the axis of resistance go back to the Iranian Revolution of 1979, which paved way for the radical Shia movement, Islam clerics to come back to power. Now, to expand its political, military, and influence in the region, where most powers such as US ally Saudi Arabia, which are Sunni majority nations, Iran's new regime began to support the non-state actors. So we definitely know what are state actors and what are non-state actors, right? So therefore, it becomes important. Now, apparently, the coalition's name first came to be inspired by from a speech by former U.S. President George W. Bush's use of term called the axis of evil. Right now, let us just go about a few things about these particular organizations. One is the Hezbollah, which was created in 1980s. It means Party of God. It's a Shiite militant organization formed to fight Israeli forces that had invaded Lebanon. Right. So we know on the border of Iran. Yes, on the border of Israel. Then there's the Israel and we have Lebanon here. Hezbollah operates on the southern part of Lebanon and on the northern part of Israel, right? And apparently, Lebanon and Israel also does not have a particular boundary, so this is also called as the blue line. That should also be known as a fact. Okay. Apparently, the second particular uh, 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 organization, which is the Hamas, we all know where it operates. It operates in the Gaza Belt. So it's again a Sunni militant group operating in the region of Gaza since 2007, emerged during the first Intifada of the Palestinian uprising against the Israeli rule. Hamas opposes Zionism, which is a political concept for the matter of Israel, right? So this also needs to be taken care of individually. Then the next one is the PIJ. Then the fourth one is the Houthis, right? Houthis become important because their response to Israel's onslaught on Gaza after October 7, the group began to attack ships crossing the Red Sea, demanding uh, an end to the invasion of the Palestinian enclave, right? So that's the reason this topic becomes important and also interesting. This is majorly about the axis of resistance. Now going, or coming down to the very important topic of this lecture. So talks about the sub-classification of the scheduled caste and scheduled tribes, right? This has been something which was going on, and this is a landmark judgment which has been given by the Supreme Court very recently. Let us begin with the important part of this particular article. It so says that in a landmark judgment, a seven-judge bench of the Supreme Court on Thursday reframed how scheduled castes and scheduled tribes quota may operate. Right now, the judgment permitted states to create sub-classifications within SC/ST categories for the purpose of according wider protection through fixed subquotas. Apparently, let us try and understand the very basic of this particular thing. There are two articles by the purview of, say, Article 341 and Article 342, right? So it takes care of the SCs and it takes care of the SCs. Now, both these articles so suggest and so tells us that it is only the right of the President of India to notify a consolidated list for SCs and STs for reservations, right? However, in case of OBCs, there are two different lists. Okay, one for the one recommended by the central government and one recommended by the state government. Now, was in news for a very long time. Why? Because there were many communities within the SCs, right? Within the SCs, there are many communities, isn't it? So, it was suggested that few communities within the SCs are powerful and they have been dominating while taking in the benefits of the reservation. So there are some other communities which have not been able to take care of the benefits very well, right? So in this particular thing, recently the Union government also formed a committee which was headed by the chief cabinet secretary of the country, right? So apparently, this particular judgment so says that the reservation for SCs, say if it is 15% for SCs, right? So this 15% will be subdivided. Of this 15%, say 5% goes to one community one, 10% goes to one community, another 5% goes to one community, right? So this is how it should be divided. And for that matter, the yardstick for the sub classification has also been provided by this particular judgment. So this is majorly about the idea of kind of trying and dividing the reservation, the whole reservation, in a vertical component, right? Such that all these communities who have not been able to exert themselves well, they now have the authority to come down and get the benefits out of it. Okay. Now getting back to the nuances of the article, it so says so reads that this overturns the Apex Court's 2004 judgment in the E.V. Chinnaya versus the state of Andhra Pradesh, in which it held that the Supreme held that sorry it held that the STs and FTs list is a homogeneous group. Right now, apparently, you can see the history of the case has been given here. Right. So what happened is initially it was in 1975 that the Punjab government gave a reservation, or for that matter, let us read this particular thing. It shall become clearer to you. So, in 1975, the Punjab issued a notification giving first preference in SC reservation in the to the Balmiki and Madhabi Sikh communities, two of the most backward communities in the state. Right now, what happened is similar thing happened in the state of Andhra Pradesh, in which the case E.V. Chinnaya versus the Andhra Pradesh government. In this particular thing, the government so said that the Supreme the Supreme Court said that SCs are a homogeneous group, right? Homogeneous group, and there cannot be subdivisions in this particular list, right? Now, what has happened is the court also said that subclassifying Supreme Court violates the right to equality under Article 14. Okay. Now, based on this ruling, what happened is in Dr. Kishan Pal versus the state of Punjab, the Punjab and the Haryana High Court struck down the 1975 issuance order that 25% to these two communities, right? So this was struck down. Apparently, what happened next is the Punjab government it came up with a new legislation suggesting Scheduled Castes and Backward Classes Reservation Services Act, which reintroduced that particular subcategorization. Now, this got again challenged in the Supreme Court, in the High Court. The High Court again struck down the case, which was again put down to the Supreme Court. And in 2014, for the first time, the Supreme Court, or for that matter, a five-judge constitution bench, so suggested that can there be a change, or can there be a reconsideration of the E.V. Chinnaya judgment which had to take place, right? Apparently, in 2020, the Justice Arun Mishra led Constitution bench in Davinder Singh versus the State of Punjab case held that the 2004 decision requires reconsideration, and that reconsideration was given by this major judgment, landmark judgment that happened very recently, right? Now, there are certain elements of importance in this particular article you can go through, which I have already mentioned. Article 341, then the provisions of Article 15, Clause 4, the provisions of Article 16, Clause 4. So apparently, all these articles or clauses of these articles suggest states have the power to categorically make appointments and make any special provision for the advancement of SCs and STs, right? Now, uh, uh, while talking about the reservation in certain chunks, we also had mentioned about if there are certain criteria. Yes, the judgment would give us certain reasonable criteria, which so suggested that the states have to demonstrate a need for wider protections, bring empirical evidence, and have a reasonable rationale for classifying subgroups, and this reasoning can be subject to the judicial purview, right? It has to be effective representation and not merely numerical representation. So this becomes a very, very, very important aspect of the judgment. Okay. Now it also reads that the state must prove that the group caste carve out from the larger group of the scheduled caste is more disadvantaged and inadequately represented, and this must be based on quantifiable data. So this becomes very important while considering the elements of this judgment. Now, in this particular thing, what was also, or for that matter, what concept had also come in was the opinion of Justice Gawai, who backed for introduction of creamy layer conception in the SCs and SCs. We already discussed about the creamy layer concept in OBCs while we were discussing the first topic, that is the Indra Sawhney judgment. Now here, what becomes important is the case, Journal Singh case, wherein the concept of in categories of Cs and Sts also did come up, right? Now, this particular thing is going to become a fact. For that matter, the Journal Singh judgment has now been again referred to a larger constitutional bench, so therefore we are waiting for it also. Nonetheless, there is a small element of hope herein because four of the seven judges, Justices Vikram Nath, Pankaj Mittal, Satish Chandra Sharma, and Justice Gawai, they have given an opinion for that matter, which calls for introduction of female layer exception for SCs and STs, while very much similar to the concept of OBCs, right? So this is judgment again, which is waited for by the Supreme Court of India. So this was majorly all for this particular session of this week. Thanking you again